Hi, Tony DeWitt, Missouri Appellate Attorney and a guy who likes to make the law make sense on YouTube. Today we're going to talk about an interesting case out of North Dakota, of all places. I hope you'll find it interesting. Let's talk about it down at the beach. So the words criminal lawyer can sometimes have more than one meaning. Sometimes criminal lawyer can mean that somebody devotes their practice to defending people accused of crimes. And in the other context, it can mean a lawyer who is a criminal. In this case, what we have is a question of whether the lawyer is a criminal lawyer or a criminal lawyer. And I'll let you make up your mind about that. This case came about because somebody got arrested for selling, I think it was methamphetamine in North Dakota. And as a result of that, they were going to be put on trial. They hired a lawyer. And then, I guess based on some jail conversations, another inmate in the jail where the guy was being kept came forward to the U.S. attorney and said, hey, this guy is planning on killing one of your witnesses. So they allowed him to get out of jail so that he could ingratiate himself to the defendant in the federal case and then become a snitch. And of course, we know that whenever the government uses snitches, it's generally because they have some weakness in their case. But in this case, I think it was really a good-hearted effort to try and keep a witness alive. But again, I'll let you make that call. So let's dive into the story and see how all this plays out. Okay, this is the opinion. It's in the 8th Circuit Court of Appeals, which I think has much nicer typefaces than the 9th. It's Henry Howe, who is the plaintiff appellant and lawyer in this case, versus Stephen Gilpin in his individual capacity, and Gilpin is one of the investigators in this case. So this is in front of Judge Loken, who is a no-nonsense judge, Judge Malloy, who is a no-nonsense judge, and Judge Cobes, who I don't know. So this is Judge Loken giving the opinion. In late 2013, Barbara Whelan, the state's attorney for Walsh County, North Dakota, and agents of the Grand Forks Narcotics Task Force were preparing to try pending drug charges against a guy by the name of Paul Lisingen. Delisha Glaze and Scott Kraft were the lead GNTF agents supervised by Steve Gilpin. The charges were based primarily on a May 2013 controlled buy a confidential informant, EB. Lisingen was represented by attorney Henry Howe. In January 2014, Stephen Anderson, facing felony theft charges in Grand Forks, told Gilpin that EB was in danger. Anderson agreed to act as an informant. He attended meetings with Lisingen, Howe, and Wesley Smith and secretly recorded comments that provided probable cause to believe a conspiracy to murder EB was afoot. Now keep in mind, we have a snitch in the middle of a law office recording comments. So on January 30, Glaze prepared and submitted a felony complaint charging Howe with criminal conspiracy to commit murder together with a supporting affidavit. A Walsh County district judge issued a warrant for Howe's arrest for that offense, commencing the criminal prosecution. Howe was arrested that day at the start of a preliminary hearing in one of Lisingen's criminal cases. Some months later, Prosecutor Whelan dismissed the amended charge against Howe prior to the preliminary hearing, after learning that Anderson previously made false murder-for-hire allegations to Nebraska and Minnesota law enforcement authorities. Howe then filed this 1983 suit against Gilpin, Glaze, Kraft, and Whelan. After reciting Anderson's lengthy prior criminal history, Howe alleged 2 Fourth Amendment violations. The warrant was based on a deliberate falsehood or reckless disregard of the truth, the use of Anderson to develop and generate false evidence incorporated into Glaze's affidavit, and 2, defendants deprived Howe of a preliminary hearing at which time Howe would have been discharged because the warrant was not supported by probable cause. Now, the court drops a footnote here, and it's kind of an important one. Howe did not pursue this claim in resisting defendant's motion for summary judgment, and for good reason. It's not a Fourth Amendment claim. You would think that a criminal lawyer would know that. Reviewing de novo, which means they look at the facts and the law as if they were the district court, we agree with the district court that the affidavit provided probable cause to arrest Howe, even if corrected to include the information that Howe alleges was recklessly omitted. Accordingly, we affirm. In other words, they pretty much believe that there was evidence that provided probable cause that Howe was in part and parcel of this conspiracy to kill E.B. The GNTF investigation revealed that in November, contacts with Haas in prison, Lysengen said he knew E.B.'s identity. Lysengen was staying with Anderson, whom he met in the county jail. And then Anderson reported to GNTF that on January 9th, Lysengen and Smith had discussed a plan to murder E.B. Smith produced a map of E.B.'s residence and said E.B. was an antiques collector. The plan was that Anderson would call E.B., discuss antiques, and arrange a meeting with Smith, who would kill her. And Rodney Avern, a drug-dealing associate of Lysengen, would dispose of the body. Glaze's affidavit recited that surveillance confirmed Anderson and Lysengen were often together. Anderson reported attending a January 22 meeting with Howe, the lawyer, and Lysengen, the defendant, about making E.B. go away. Howe said, quote, "It would be good if the beep died or went away." Lysengen asked what would happen if E.B. did not show up for court. Howe responded, they wouldn't have a case. Lysengen then said, if she shouldn't show up, then she won't show up. 2 days later, Anderson wore a body transmitter to another meeting with Lysengen and Howe. Howe explained that E.B.'s presence is necessary for the state to proceed with the prosecution. If she's not around, he said, it's like, quote, a house of cards that falls down. Howe said that E.B. being gone needs to happen more than 5 days before trial, or it looks suspicious. Now, I'm not saying that he's a bad lawyer, but I'm just saying that anytime E.B. goes away, it looks suspicious. I'm just saying. Howe should have known that. Howe said the government won't have E.B. come to the preliminary hearing. If she did come, Howe would probably cancel the hearing so that the prosecutors could not use her preliminary hearing testimony if she was not present at trial. So, oh boy, there is a big issue right there that suggests that he is in league with these criminals. And he's recorded on saying that. They're in there looking for legal advice, and that could be a problem. Now, there is one way around that for the government, and that is they can claim the crime-fraud exception. Although it may be slightly different, this is a statement about the attorney-client privilege and the crime-fraud exception. There is the crime-fraud exception wherein a person cannot employ an attorney for the purpose of aiding and abetting him in the commission of a future crime or fraud, and thereby prevent the attorney from exposing such crime or fraud by sealing his lips via the attorney-client privilege. In Missouri, the crime-fraud exception requires that the party seeking discovery make a prima facie showing that the party asserting the privilege has committed a crime or a fraud, and must also demonstrate that the privileged material has a direct and contemporaneous relationship to the crime or fraud. A bare allegation of fraud is not sufficient, or crime, either one. They can say that because he was part and parcel of planning this crime, that the normal protections that are inherent in the attorney-client relationship are gone because he's helping the criminal plan a crime. Government put together an affidavit reciting all these facts, and they went and got a warrant. Anderson reported that as the plan developed over the weekend, Anderson was to call E.B. at a number Smith and Lysengen provided and arrange to meet E.B. at a storage unit in Grand Forks. And then do ugly things to her. The Grand Forks, Nevada task force asked EB to leave the area for her safety. The affidavit was corroborated by Anderson's wire-recorded conversations and by Lysengen's prior communications with Haas. In addition, GNTF verified that Smith, Lysingen, and Avron knew each other. So Anderson knew EB's first name and provided a copy of the map that also substantiated his information. Anderson had felony charges pending in Grand Forks and Cass County. Glaze was aware of the pending Grand Forks charges, not the Cass County charges, and her affidavit did not disclose this criminal history. While the criminal charge was pending, Howe's attorney hired an investigator to conduct a background investigation on Anderson. In March, in response to Howe's discovery request, Whelan obtained a triple-I report on Anderson, which is where they do an expanded background check on the informant to make sure that he's reasonably clean. It revealed numerous additional charges for forgery, theft by deception, false promises, and false representation. In late March, Whelan received documents disclosing that Anderson made false allegations of murder-for-hire plots in Minnesota in 2003 and Nebraska in 2004. Neither incident resulted in criminal charges, so they were not on the triple-I report. On April 24th, Whelan moved to amend the charge against Howe to criminal conspiracy to tamper with a witness. On May 8th, the day before the preliminary hearing, Whelan moved to dismiss the amended charge against Howe. In an email to Howe's attorney, Whelan explained that in light of the information made available, although she remained confident there was probable cause, she didn't see any need to go through tomorrow's preliminary hearing because she wasn't sure she could prove it beyond a reasonable doubt. They dismissed the case and this lawsuit followed. So the issue here is whether the warrant was sufficiently supported by evidence of probable cause that had been legally obtained. And essentially what the court finds is, look, even if you discount the stuff that came out of Howe's own mouth, it's pretty clear that at least after there was evidence of a murder-for-hire plot, the deliberate falsehood issue, in other words, the deliberate falsehood in the warrant, turns on the mental state of the affiant, Glaze, not the informant, Anderson. So in other words, what Glaze knew, not what Anderson knew, is what's at issue. Glaze failed to disclose that Anderson had a criminal history, establishing that he's a chronic liar, which raises a genuine issue of fact regarding Glaze's reckless disregard for the truth. However, and reckless disregard can be inferred from the omission of information. However, the party attacking the warrant must show the omitted material would have been clearly critical to the finding of probable cause. In a warrant affidavit, the government needs only show the facts are sufficient to support a finding of probable cause. The core question in assessing probable cause based upon information supplied by an informant is whether the information is reliable. And here is whether or not the application is so lacking in indicia of probable cause as to render official belief in its existence unreasonable. Omissions and falsehoods that are immaterial or are not supported by the record do not suffice. Standing alone, the objective evidence contained in the affidavit, most importantly the detailed recitation of statements made by Howe, Lysingen, and Anderson at the recorded January 24th meeting, provided probable cause to believe a conspiracy to murder E.B. existed. Opportunities to assess Anderson's credibility firsthand gave greater weight to the informant's information. Many informants have prior convictions. Omitted information must be clearly critical. It was not plainly exculpatory evidence. If anything, it was consistent with an inference that Lysingen and Howe had involved Anderson in a criminal conspiracy. Thus, there was no Fourth Amendment violation. Officers are not required to conduct a mini-trial before arrest. There's no evidence that Whelan or GNTF investigators knew about the false murder-for-hire allegations when Glaze submitted the warrant affidavit. An agent does not violate a clearly established constitutional right by omitting information from a warrant application that he does not actually know, even if the reason is his own reckless investigation. As Howe's subsequent lengthy investigation of Anderson makes clear, minimal further investigation into Anderson's criminal history would not have exonerated Howe. And given the imminent threat to safety, Time was of the essence. The judgment of the district court was affirmed. This guy recorded him being a part of that. So let's look at what they say. So it seems pretty apparent to me that there was at least some reason to believe that the lawyer involved was participating in a criminal conspiracy. And under the rubric of no good deed goes unpunished, when the prosecutor dropped the charges, he immediately filed that civil rights complaint. And I think you have to look at the totality of the circumstances, which is a phrase that is used in the law a lot to describe situations where the court looks at everything and kind of gives it the old, rule of thumb, and if it looks like a duck and it quacks like a duck, it's not a pigeon, even a stool pigeon. But the bottom line here is that although the prosecutor was using somebody who was a snitch, there was some indicia of, at least according to the recorded conversations, that the lawyer was participating in a scheme, because he said, it would look awful funny if the person, had an accident right before trial, whatever the words were that were used in the actual opinion. So there is at least some thought that maybe, the guy wasn't necessarily 100% on board. And as a result of that, the U.S. attorney dropped the charges, and I think that was good for him. And although they dismissed the charges, nothing prevents them from refiling them if indeed later on they develop additional evidence. You see, the problem was that when you use a jailhouse informant against and in particular in this case, when you use a jailhouse informant, you have to be aware that people learn that trick from somewhere. And this guy had learned it, and he had tried it several other places, because under the federal criminal rules, you can get essentially a get out of jail free card, or at least get out of jail early card, for doing this kind of thing, informing on other individuals and stopping criminal acts that are in progress. And so when the DA found out, or when the U.S. attorney found out that he had done this previously and had been essentially, even though he hadn't been convicted of perjury, he was at least discredited in the eyes of the government, she did the right thing and dropped the charges. First, she reduced the charges, and then she dropped them. And I think that was a good thing. Fortunately, in this case, in the civil case, the court took a look at this and said, based on what you said, there was an indication that you were part of this, so you're not exactly innocent in this regard, so we're going to dismiss your case. I think that's how you read this case, and I think it's fairly obvious that that's what the district court did, and the Eighth Circuit, which is a very practical appellate court. The only thing it routinely screws up on is False Claims Act cases, and that's just because they don't understand it, I don't think. But in this case, I think they understood things perfectly well and got to the right result. So that's what I have for you today. If you have any questions, please feel free to leave them in the comments down below. Like, share, subscribe. You know all the things I ask you to do. And I always tell you that, I don't do this at the beginning of the video like many YouTube presenters do, because I don't think it's fair for you to be asked to subscribe before you've judged the quality of the content. So hopefully you found this interesting, and if you would, I'd love to have you as a subscriber. And if not, thank you so much for being here. Go out today and do something kind for someone else. Even though that guy drove down the side of the road and he could clearly see that the right lane was closed in 1,000 feet, go ahead and let him in. Yeah, he's a jerk, but you know what? Kindness is never repaid, it's only passed on, and maybe somewhere down the line he'll do something kind for someone else. So, thank you so much for watching. Have a great day, and catch us down here at the beach next time. If you like this video, here are a few others you might try, and don't forget to subscribe. Have a terrific day, guys.